Morning, everyone. We're going to call the Committee Family, Seniors, and Health to order. Mr. Secretary, please call the roll.
Senator Carter.
Here.
Senator Nicola.
Here.
Senator Hudson.
Here.
Senator Lewis. Senator Moon. Senator Nurenberg.
Here. All right, quorum is established. We will now begin our hearing. We are going to hear Senate Bill 66 first. We're going to give 15 minutes for, and then 15 minutes, correct?
Yes. Yep.
15 minutes for, 15 minutes against, giving a half hour in total for the bill. So if our bill sponsor is here, Senator McCreery. Very good. Good morning, Senator. Begin when you're ready.
Good morning, everybody. Thank you so much for hearing Senate Bill 66. I am honored to be here this morning. I'm State Senator Tracy McCreery. I represent a large portion of St. Louis County, and I am going to present Senate Bill 66. So the current law in the state of Missouri right now is children aged 16 and 17 can be married with parental consent. Senate Bill 66 would raise the age of marriage for all parties involved to 18. So both parties would have to be 18. I believe raising the marriage age to 18 is imperative to the health and welfare of children, particularly young girls here in the state of Missouri. Right now, currently, Missouri ranks 16th when it comes to child marriage per capita. Child marriage puts children at risk of mental and physical health issues, intimate partner abuse, social isolation, and poverty. This is not only a legislative imperative to me, but a moral one. It's time we raise the age of marriage to 18 to protect Missouri children. Let me be very clear about something. Child marriage is the legalization of child rape. If a 21-year-old were to have sex with a 16-year-old, that would be second-degree statutory rape. Just because one parent gives permission for the child to be married doesn't make it not rape. I'm very, very thankful to former colleagues, Senator Holly Thompson-Rader and Senator Lauren Arthur, for their tireless work on this issue the last couple of sessions. I'm also thankful to all of you for your overwhelming support of this legislation. I'm kind of picking up the baton where they left off, and I'm hoping we can get it across the finish line this session. And I'm happy to take any questions. I also have amazing witnesses, so.
Thank you, Senator, for your
Thank
presentation. Are there any questions for the Senator? Seeing none, we'll go ahead and begin with our testimonies in favor of. Keeping it to 2 minutes. Yeah, if you could keep your testimony to 2 minutes, just so we have enough time to hear everyone. We'd appreciate it. Just leave it right there.
Yep.
Yeah. Just also make sure your mic is just turned on.
Yes.
Thank
All right,
you.
I'll speak very quickly. So I'm here as a survivor. First of all, I'm a forced marriage survivor. My name is Frady Reese. From my experience, my traumatic experience, I founded Unchained at Last, which is a nonprofit that is dedicated to ending forced and child marriage across the U.S., including here in Missouri. So this is personal for me. I'm also an advocate and an expert on this issue. Research and writing have been published extensively. So as you heard, the current law, the current marriage age is extremely problematic at 16. When somebody is forced to marry, their own parent almost always plays a crucial role in facilitating it. That was true for me. That's true for the more than 1,100 survivors we have worked with at Unchained. We have worked with girls who showed up sobbing at the clerk's office, nothing the girl or the clerk or anyone else can do once that parent signs the form. But also what we're doing is legalizing and incentivizing the trafficking of minors under the guise of marriage. And this is because federal law doesn't specify a minimum age for spousal or fiancé visas. Instead, it defers to state law. And the state law in Missouri says 16 and 17-year-olds can be entered into marriage. So that means right now, 16 and 17-year-old girls in Missouri can legally be trafficked for their citizenship, forced to marry adult men overseas, so the men get a visa and a path to citizenship, and men in Missouri can legally import child brides of age 16 or 17, legally sex traffic them under the guise of marriage. And this is not a small problem. The U.S. Senate Homeland Security Committee issued a report recently that showed thousands of minors are being trafficked under the guise of marriage, almost all of them girls married to adult men. The way to stop this is to do what Senator McCreery and Senator Bratton has also introduced a bill to this effect, make the marriage age 18, no exceptions. It costs nothing, it harms no one, and it ends this, what the U.S. State Department calls human rights abuse marriage before the age of 18.
Thank you. Thank you for your testimony. I have a quick question.
Sure.
Does it change at that point of them being 18 years old? Then there's no signature for the parent needed. Is that partly the goal as well, as that it's just
That
the
is
initiation basically of the individual having nothing to do with the parent?
exactly. So at 18, you can contract at age 18.
Yes.
And the reason that's so crucial, because yeah, you can be forced to marry when you're 18. I was forced to marry at 19. The difference is there are legal options. When you are not yet 18, you cannot easily leave home because you're a runaway. You cannot get into a domestic violence shelter. They'll almost certainly turn you away. And you cannot easily retain an attorney because contracts with minors are avoidable. You're not even allowed to file for divorce because you can't bring a legal action. So we're talking about parents entering these kids into this marriage, and there's no recourse for them. They're just trapped once they're in it. They have to wait until 18 to file for divorce. And at that point, they've experienced the trauma. They've pulled out of school, raped repeatedly, probably been forced to have children without their consent, and now they're really stuck.
I just wanted to make that clear, and there was a delineation there as to why 18 was so important. So Thank you.
Exactly. And it's nothing to do with maturity. You don't wake up on your 18th birthday with a newfound wisdom and maturity. You wake up with the rights of adulthood.
Thank you. Any questions for this witness?
Thank you so much for your testimony, and obviously you seem very passionate about this issue. So I appreciate you bringing this concern to the committee. You mentioned some data about young women being married to older. Do you have that in your testimony? I'd like to just see some data, some
absolutely.
statistics on that.
Yeah, and so the statistics that I mentioned in my testimony were specifically about girls being trafficked to the U.S. under the guise of marriage, and girls being forced to marry adult men overseas, trafficked for their citizenship. I do have the data specific to Missouri, and I can share that with you as well. And I did submit written testimony, and it is included there. But between 2000 and 2022, there were 8,289 minors entered into marriage in Missouri, and that includes, by the way, 282 who were married since 2019. That was when the legislature last updated the law. It used to be the marriage age of 0. They moved it to 16, which was a good first step. But because of the fact that 88% of the minors who married in Missouri before that time were age 16 and 17, it didn't make much of a dent. We still have hundreds of minors being married. And by the way, of the minors married, 78% were girls married to adult men, an average of almost 4 years older.
Did you say 2,800 just in Missouri, or
8,289. That's just in Missouri.
Thank you, ma'am, very much. I appreciate it.
I just want to add something to that because you're newer to the legislature, and I'm so happy you're here. When the legislature a few years ago raised the marriage age to 16, we patted ourselves on the back and did a victory lap and thought we were doing some amazing things. But the reality is only protected 12% of the kids that were getting married. So I think we realized that we were really not getting at the root of the problem, which is why we're back here now talking about 16 and 17-year-olds.
Thank you, Senator. Any other questions for the witness? Seeing none, thank you for your testimony. Next, for those in favor. Just make sure you filled out a witness form to leave there on the desk, and begin when you're ready. Push the green button.
With me.
No worries.
All
Take
right.
your time.
Can you hear me? Okay. So good afternoon. My name is Brandy Dredge. I live in St. Joseph, Missouri, and I'm an author, a teen mom, a child marriage, domestic violence, and sex crime survivor who proudly sits here today with Unchained at Last and my fellow members of the Missouri Coalition to End Child Marriage as a survivor ally. When I was 16, I met a 24-year-old man who lived with some boys from my high school, and with stars in my teenage eyes, I believed he hung the moon. 4 months later, I was pregnant, and a year after that, I was begging my mom to give parental consent for me and my boyfriend to get married after the attorney representing him on criminal theft charges suggested we do so before his sentencing. Since my boyfriend was a persistent and prior felon, the attorney wanted to use the marriage in the arguments for leniency on his sentence to show the judge that he was a changed man, a family man with a new wife and a baby. In 1997, at 17, I became his bride. He was 25, and it worked. He did get a suspended sentence. Over the next 9 years, the statistics surrounding child marriage, such as the high likelihood of poverty, lack of further education, enduring many forms of abuse, would ring true in my marriage, in addition to the fact that I had married a sexual predator, which was something that I struggled to see even after the sheriff leading the sex crime investigation said that the only difference between me and the other girls he had sexually abused was that he married me. And I had evidence of the crime, my son's DNA. We got divorced in 2007. He was convicted of 2 counts of statutory rape. One of those counts of statutory rape was for the crime that he committed against me. When Missouri changed the law in 2018, one of the supposed safeguards was that the party marrying a minor may not be over the age of 21, which was a step in the right direction towards protecting our children. In fact, had that change had been enacted in 1997, it would have protected me and stopped my mom from making a decision that she believed was the right thing for me and my family. With hindsight, I can see the manipulation, the grooming, and how the long-term effects of abuse and trauma have played out in the lives of me and my children. I can look back at that starry-eyed teen and I can say that wasn't the right thing, and I'm sorry no one protected you. It has taken me a lot of years to finally see, accept, and say, I am a child, marriage, domestic violence, and sex crime survivor. I lost my childhood, and along the way I lost myself. I rationalized many bad things under the guise of marriage. I couldn't see them as clearly as the sheriff, the prosecutor, and the judge could, which is why I am here today, to help others see what I couldn't. Times change. When we know better, we do better, and there are still children the current marital law doesn't protect. We know this, and we can't rationalize and or ignore this. We must stand by the truth that children are children until they reach the age of majority, which means 16 and 17-year-olds are children too. So in 2025, let's do better, close the loopholes, lead with common sense, and protect all of our children by declaring that children shouldn't be married before they reach the age of 18, no matter what. Thank you for your time.
Thank you for your testimony, and thank you for taking time to be here today. Is there any questions for this witness? Go ahead, Senator.
Ma'am, I want to thank you so much,
Thank you.
because it has to be terrifying to come and speak this in front of us. And I want to thank you for doing that. Thank you for taking your time to come here and share your story.
Thank you. I appreciate the opportunity.
Absolutely. Thank you very much.
Thank you. Thank you for listening.
Any other questions for the witness? Just appreciation, I think.
Thank you.
All right. Next, in favor? No worries.
Most of these folks remember me being on a scooter a couple of years ago, so they're going to be very patient, yes.
Just
This
begin
side?
when you're ready. Yep.
Okay. Good morning. Thank you for allowing me to be here to speak with you today. This is very difficult for me because sharing my trauma is not easy. I'm Sheena Eastburn. I'm from Joplin, Missouri. 45 days after my 15th birthday, I married a man almost 21. Within the first month, I was hit. Within the second month, the first sexual assault happened. It was not rape because we were married and I was a wife and I was to submit. For 2 years, I endured physical, sexual, mental, and emotional abuse. The only problem was I was at 18, so I couldn't go to a domestic violence shelter. I couldn't even get a restraining order until my mother actually seen him beating me physically, and she took me to the courthouse and had to sign to help me get a restraining order. I couldn't get a lawyer. I couldn't advocate for myself. I even ran away, and they took me right back to my abuser because I was a juvenile. I attempted suicide 2 different times. And then 2 years and 4 days later, I was arrested for his murder. I did 25 years in the state penitentiary. I was sentenced to life without parole. I'm the first female to come home under the juvenile law. The abuse was able to come out, and I was able to finally share my voice of what happened to me. I ask that you support this bill because even though I was emancipated, they said I was emancipated, but I wasn't. I still had no rights because I was not 18. I could not escape. He was even able to put me in a lockdown unit and say I was crazy because I wanted out. So I ask that you please support that if I'm not old enough to vote, I shouldn't even be old enough to get married. So I thank you for listening to my testimony.
Thank you for sharing your testimony, and it's a long drive from Joplin, as I well know. So thank you again for your time. These are tender issues that we're talking about, and so just taking the time to come up here and be vulnerable with us it means a lot to us too, to know your story. So thank you.
Thank you.
Any questions for the witness? Go ahead.
Comment. I just want to echo the chairwoman's sentiments. So thank you too for coming. And I know, like you said, it's very difficult to share trauma in public like this. So I just want to thank you very much.
Thank you.
This is so important for us to hear the experiences that you and others have gone through. And I want to speak for myself. I hear you. Okay?
Thank you.
So thank you.
Thank you.
All right. Next, in favor? This is a familiar face in this building. Yes. Welcome back, Senator.
Thank you for having me. This is exciting.
Begin when you're ready.
Thank you, Madam Chairwoman, and members of the committee, and new members that I haven't gotten to meet yet. I am Holly Thompson Rader, and I'm here on behalf of myself as a child bride. I got married at 15. My mother struggled with mental illness. I talked her into letting me get married to my 21-year-old boyfriend because we had lived in horrific domestic violence for many years, and I knew that I was never going to get out of that with him, and I couldn't watch her almost being killed in front of us any longer. And my boyfriend and I had just turned 15. We had dated for 2 years. So we started dating when I was 13 and he was 19. That's the world that I grew up in. My sister at 16 married her 39-year-old drug dealer. My cousin got married at 16, and she married a man much older than her as well. I'm here to talk about, as a Christian grandmother and as a Christian yaya and mama, the mental health side of it that I went through, and that I know that these girls go through, even the ones who aren't forced into it. 31% are more likely to live in future poverty. I got pregnant 5 months after I got married, and at times I was homeless while I was pregnant. I was couch surfing. That's a part of it. 50% are more likely to drop out of high school. I did drop out of high school right after I got married. I no longer fit in with kids that were my age, but I didn't fit in with adults either. I was 15, but I was an adult, but I was a child. I was very isolated and alone. Girls who marry before, anyone who marries before they're 18 are 4 times less likely to graduate college. Victims of domestic violence at rates 3 times greater than the national average. And almost 80% of these marriages end in divorce. Mine ended in divorce after 7 years, on and off, the whole 7 years, trying, of course, because I didn't want, my mother was married 5 times, my father was married 7 times. I didn't want to give my children that type of home. And so I really tried to stick it out. But I just want to say that with those type of statistics, that is the reality for even those who enter into this feeling like, hey, this is what I want to do. It still ends in terrible statistics. And when you look at an 80% divorce rate, a parent should not be able to sign their child up for what I see as a lifetime commitment. So I ask that I'm excited to be here to support Senator, and I'm happy to answer any questions. Sorry, I went past my time.
We'll show leniency with you this time. Thank you for your testimony, Senator. Any questions?
Good morning, Senator.
Good morning.
I just want to thank you for shining a light on this important issue. And even though you're no longer in this body, that you continue to use your story and your platform to elevate this for victims across the state. I had a constituent reach out to me, and I know she worked closely with my predecessor, Senator Arthur, as well. And one of the things that she shared with me, I'll never forget. She said, even though I'm grateful for the 4 children that came from this terrible situation, and I wouldn't change the course of my life, I would never wish this experience on anyone else. And that's what we're here.
I absolutely feel that. And that is, my ex-husband is a part of my family, and he spends every holiday with us. He called me yesterday morning to make sure my cold was better. But I was too young to make that type of a decision, and I derailed my life. And I know that 50 years ago women were getting married younger, but we did not have the opportunity that we had now. We couldn't even have our name on a bank account. Things are different now, and these statistics are staggering. And so, in my testimony that I'm turning in,
Thank you.
I've included an article that I wrote, an op-ed that I penned, that just gives a little more of a story, and I've made a copy for everyone for that. So.
We'll make sure that gets distributed to the committee. Thank you, Senator, for being here today.
Thank you, Senator. You're a brave, strong woman, and I really hope we can finally get this in its correct form across the finish line.
Thank you. Okay. Okay. We're going to move to opposition. Anybody opposed to this legislation? Is there anyone else here in favor of the legislation? Okay. Since there's nobody here in opposition, we're going to go ahead and hear the testimony for the next 15 minutes in favor if we still need that time. So go ahead and come up if you're in favor of the legislation.
Good morning. My name is Matthew Huffman, and I am the Chief Public Affairs Officer at the Missouri Coalition Against Domestic and Sexual Violence. Madam Chair and members of this committee, I appreciate your time this morning and that you are hearing this very, very important bill, and I want to say thank you to Senator McCreery for taking this up. There's not much more I can say, honestly. The very powerful and brave testimonies that you have heard this morning from these survivors of child marriage is exactly why the coalition stands with survivors and supports this legislation. I think it's very important that you're able to hear this lived experience from survivors, and it is that lived experience that helps us make better public policies. We are fully in support of this. Thank you.
Thank you for your testimony. Any questions for this witness? Seeing none, just make sure your witness form's left there on the desk. Next in favor? Just begin when you're ready.
Good morning. My name is Becca Powell. I work for Unchained at Last, and I also run the Missouri Coalition to End Child Marriage. I'm here testifying in favor of SB66 because child marriage produces devastating lifelong repercussions that destroys nearly every aspect of an American girl's life. Studies show it destroys everything from her health, her education, her economic opportunities, and her physical safety. She's more likely to experience intimate partner violence, both physical and sexual, and be forced to endure pregnancy, childbirth, and parenthood without her consent. And as you heard from earlier testimony and from all the heartbreaking stories. That's why our own U.S. State Department calls this a human rights abuse. And I have some written testimony I'll submit that is on behalf of service member groups who also want to see an end to child marriage all across the U.S. and legislators in the 13 states that have already set the marriage age at 18 with no exceptions. Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none? Appreciate it. Anyone else here to testify in favor of the legislation?
Good morning, Jessica Seitz, representing Missouri Network Against Child Abuse, and I too do not have anything to add. I want to thank those for their bravery who spoke before me. We're here in support. We want to thank the committee for hearing this bill right out the gate this year. So
Thank you. Thank you for being here. Any questions for the witness? Seeing none, appreciate your time and testimony. Anyone else in favor? All right. With no more witnesses in favor or against, we will move on to our next Senate bill. Senator, do you have any closing comments?
I just wanted to thank Senator Rick Bratton for filing identical legislation. He filed that on Monday, so we'll have to have a discussion about, what if we try to roll these bills together, but that's something for the committee to decide later. But I just want my colleagues to know that there's companion language coming from the other party. So,
All right, thank you.
Yep, thank you.
for your work on this. We'll make sure that the witness forums and the information that are in the witness forums get sent to the rest of the community. I don't think so. I think we're good. Just later, yeah. All right, what's our next Senate bill? All right, we're going to begin testimony on Senate Bill 83. It doesn't seem pretty any contested. Yeah. Yeah, awesome. This is 83. All right, this is Senate Bill 83. Senator Berger, begin when you're ready.
Good morning, all. Good morning, Chairwoman Carter, members of the committee. For the record, I am Senator Jamie Berger, representing District 27, which includes Scott, Cape, Perry, Ballinger, Madison, Iron, and Reynolds. And I got to say them in order, if not I forget one, so I always say it the same way. Thank you for the opportunity to present Senate Bill 83. Senate Bill 83 has different facets, four provisions, all relating to child protections. First, Champion for Children tax credit. Currently, a tax credit may be claimed in amount equal up to 50% of a verified contribution to CASA, a child advocacy center, or a crisis nursery. Senate Bill 83 would increase the amount to 70% and would extend the expiration date from December 31, 2025 to December 31st of 2031. It will also raise the annual cap for the credit from $1.5 million to $2.5 million. Second, Senate Bill 83 would allow homeless youth to access a free copy of their state ID. It includes a non-driver's license or an intermediate driver's license if they have previously passed the permit exam. Missouri statute and federal law both have existing definitions of homeless or unaccompanied youth that this bill references. Third, this bill will protect medical examination services for children experiencing abuse. Will allow the collaborative practice arrangements requirements for advanced practice registered nurses and physician's assistants to be deemed satisfied by the safe care provider peer review and mentoring relationship set forth in statute already. Lastly, Senate Bill 83 deals with evidence admissibility for minors and vulnerable persons. Under current statute, children ages 14 and over lose protection for evidence admissibility, such as the CAC forensic interviewer being allowed to testify or the playing of a forensic interview DVD. This legislation would extend these protections to all minors under age 18. I do have some expert witnesses behind me who have much more in depth to these provisions And thank you for allowing me to present, and I'm happy to answer any questions.
Thank you, Senator, for your presentation. Are there any questions for the Senator?
Yes, ma'am.
Senator Moon?
Thank you. Good morning, Senator Berger.
Good morning, Senator Moon.
As I read over the bill, it looked to me like there might be multiple subjects in the bill, and wondered if you had taken in consideration the provisions for single subject.
You know, I did, and I think everything is negotiable as we move forward. I think this is a multifaceted bill that they kind of all mirror together to an extent as to one single subject, but at the same time, there's different facets of it. So that's kind of why I moved it forward the way I did.
I guess the one that kind of struck me as far-reaching would be the collaborative practice, because I think we could probably use a lot of different things that would be protecting kids, and that may, but just the scope of that, I think, may be a stretch. So maybe we could talk about that
Sure.
in future. Now, in addition to that, with the collaborative practices, since we have less restriction in the mileage, have you considered that in trying to come up with a collaborative agreement that would actually work for you?
The one thing we're kind of faced with in southeast Missouri, especially when you get below Cape Drought all the way to the Arkansas line, or basically deeper in the Boot Hill, we just don't have all those people practicing that we need to have practicing. So we have to depend on APRs and physicians' assistants to do some of those things, collaborative agreements that the hospital has a scope about, or possibly the doctors have agreements with. So that's kind of where that is.
Well, I guess on that line, you do have hospitals down there, but
Sykeston is furthest south hospital. Then you have
Right.
80 miles to the Arkansas line. And we do have a medical facility, I guess you would say, at Kennett, but it struggles continuously.
well, does the hospital allow collaborative practices with the
Yes,
nurses?
they do. And it's kind of written into their scope of definitions as a hospital policy, and also backed up by the doctors.
But still having difficulty making that work.
We can make it work, but we don't have a lot of times we don't have the people in places that we need, so we have to rely on other people that aren't normally into those things. Like when the APRNs do these examinations, they do it under the guise of the hospital or the guise of the physicians, where you normally have other people maybe do those in more urban settings.
Okay. Well, do you believe that the patients would benefit from having a physician involved in their care?
Well, I think they always would, but sometimes they're not always readily available. So
Okay.
if something happens to a child and they have to be examined in that time frame, we have to be able to do it somehow if a physician's not available, and we have to use APRNs or whoever else it may be that's available at the time that have the training and approved by the doctors in the hospitals.
Okay. Well, I may have some additional questions. I think one of the things that I think we do need to fix before I can support it would be work out the different subjects that are addressed in the bill, and maybe separate those. But we can have some more discussions later if you'd like.
I'd love to have those conversations, and some of these people behind me may be well served to answer those questions.
And
too.
I may ask them some of the same
Sure,
questions. Thank
sure.
you.
Any other questions? Seeing none. Senator, we're going to start with those who are in favor of the legislation. Try to keep your comments to 2 minutes or less.
All right. Hi again. Good morning. Jessica Seitz, representing the Missouri Network Against Child Abuse. My organization is the State Association of Child Advocacy Centers, and that's relevant to say that every piece of this bill relates to child advocacy centers in some way. So I can speak on most of the parts, but there's several folks available who are able to kind of go through and talk about the tax credit and the hearsay and the APRN about their own experiences. But I thought I'd use my time to kind of answer the questions about the APRN legislation, if that's all right. Mm-hmm. I'm happy to answer anything else. This piece in this legislation, this is the first time it's been introduced. And we want to thank Senator Berger for bringing it up, because the issue was brought to my attention actually by the Child Advocacy Center in his district. A child advocacy center, for those of you not familiar, is a nonprofit. There's 15 throughout the state that provide on-site forensic interviews for children that have been sexually and physically abused in a child-friendly way. The idea is that a child does not have to tell their story over and over again to Children's Division, to law enforcement, and so on. At some CACs, especially in our more rural areas, they're also offered the opportunity to have a medical examination on site. And in order to offer that, they have hire APRNs, and they have them on, in their center as employees. And because they operate outside of a traditional healthcare setting, it's not a clinic, they have experienced challenges. So to answer your question, they have experienced challenges in obtaining a collaborating physician because they are not affiliated with the hospitals. And they have, unfortunately, the hospital systems in some of these areas do not allow, because of their own requirements, their physicians to collaborate with anybody not affiliated with their hospital system. So if you have to be an independent physician. So that's just sort of letting you know that has actually been a huge barrier. It took my center down in Poplar Bluff over a year to find someone. So if you don't, I have one final to answer your question, is about whether they have interactions with another, like in support from a physician. In order to be a provider who is licensed to provide medical evaluation in Missouri, you have to be in good standing with a mentor that's assigned to you, and this is in statute, required in statute. That is a child abuse pediatrician at one of the children's hospitals. And so essentially having the mentor and the collaborating physician requirement is kind of duplicative. And so that's why we propose this very narrow solution that would waive the collaborating physician requirement if they're in good standing with their mentor.
Okay.
So.
Question? You have a question?
Yes,
Jennifer?
I'd
Okay.
like to clarify. You mentioned the collaborative physician, and I thought I heard you say had to be with the hospital or have to have some association with the hospital. Then you mentioned the word independent. So help me understand that.
So it is that the barrier that we've experienced and the challenge is that most of the physicians, even if there is also a shortage of physicians, but even those that are in the area, nearly all of them are affiliated with a hospital system. So Mercy, SSM, and so on. They do not allow their physicians to collaborate with APRNs that are not within the system. So because my centers are independent nonprofits, they have their only option is to try to find someone, and that's very difficult, especially in my more rural. And right now we have 5 of my 15 centers that have medical on site. So just letting you know how many. This is only under 20 individuals that this legislation would impact, but for those that it would have a profound impact on removing barriers.
So their decision is not to collaborate with nurses outside their system. That's their internal policy. But there doesn't seem to be a problem if they decided to do that in the future. Do you see any difficulty if they collaborated with nurses outside their system?
If the hospital system changed they've tried for years to try to do this. And even after a hospital system was purchased by New, they went back and still said no. That's the internal, I don't know all the details, that's their own decisions. There is a cap on APRNs where physicians in Missouri can only be a collaborator for 6, so that they may not think their doctors have that availability to do it, and so on. So, I don't know what everybody's individual. I can just say that it has been a barrier. And the one other note is that a collaborating physician does not have to be trained in the specific training that our safe care providers are trained in. So you could actually have a collaborator that is not trained.
And one question on another note here, does your organization also participate in counseling for emotional abuse?
Yes. So depending, child advocacy centers share the same accreditation standards. One thing that they're required to provide in-house or with a service agreement, depending on the center, is evidence-based mental health therapy.
Okay, thank you.
Any other questions for this witness? Does Joplin happen to be one of those centers that has
Yes. Yes.
All right.
So we've got Joplin, the Springfield area, also there's satellite in West Plains. So
Those
very
are the 3 that have.
and then some of the lake, and then the 2 in the southeast.
Okay. Great. All right. Thank you for your testimony. Thank you for being here today. Next in favor of Senate Bill 83.
Good morning, Madam Chair. David Winton here on behalf of Kids Win Missouri, statewide advocacy group that works on child welfare issues. And I want to be super brief. I'm quite sure that most of the issues around this bill really focus in on this conversation around APRNs. So I wanted to just give a little bit of context to this, maybe be helpful, hopefully. First issue is the three independent pieces of this bill are specific to child advocacy centers. So in terms of single subject, this is essentially a set of changes or extensions that benefit child advocacy centers to do the work that they do. And so I think that's one of the reasons why you see these three pieces in one bill. They all tie into a single source and a single subject. In terms of the APRN issue, so just to clarify, we are not in opposition to collaborative practice agreements or anything. This is a very strange kind of arrangement for what we do. APRNs in these settings are not like normal APRNs that go into clinics and they perform all kinds of work. We see them every day, if somebody comes in with a flu or anything like that. These folks are all under collaborative practice. If an APRN in a child advocacy center is working in a clinical fashion, this would not excuse them from being part of a collaborative practice agreement. They would still have to do that. If they were seeing patients for flu symptoms, anything in that scope of practice, it would be there. Under the current statute in Chapter 210, which is our child welfare statute, it specifically lays out the requirements and the credentialing required around APRNs working in child advocacy centers specific to forensic examinations. And so in that statute, it is required for every APRN doing this work to be connected, we call it a mentorship, but to be connected to a pediatric physician at a children's hospital who is specially trained in working with kids. So when we talk about this, we have two different collaborating practice agreements. And all we're doing here is saying, it seems logical that a pediatric physician at a children's hospital supervising the work of an APRN in a child advocacy center doing forensic training should suffice for that relationship, for that supervisory relationship. It is the highest level of practice that those guys have. They have the highest level of certification, and they're required by statute to be working with these folks. This is duplicative, and what it's going to ultimately do if we cannot get doctors to do collaborative practices, not to mention it's expensive and it's difficult. If we can't do that, and one of these CACs closes, for example, in Senator Berger's district, that means that family is going to have to transport a kid that's been abused to St. Louis or some other center to get that forensic examination. And that's what we want to prevent more than anything else. We're not opposed to collaborative practice arrangements. We understand the purpose. We believe we have something that is as good, if not better, than that arrangement already in statute.
Thank you for your testimony.
You
Does
bet.
that answer your question, Senator?
I have to chew on it a little bit.
Okay, thank you. Any other questions? Thank you for
Thank
your
you, sir.
testimony. David, did you just did you get a witness form and
I will.
leave it? All right, thanks. Where are we at on time? Okay.
Good morning. My name is Kendra Eads. I am the Executive Director of the Southeast Missouri Network Against Sexual Violence, and I am so thankful to our Senator for bringing this bill to you all. I'm here also to talk about the APRN issue. I actually brought this to Jessica at Monaca as one of her members a couple of years ago when I was here doing a Missouri Foundation for Health Hill Day. And the issue for us, so I will say we serve 8 counties in Southeast Missouri, and we do employ APRNs at our center. The reason that I brought this to her is that we have 2 hospital systems in our region. Now Mercy, it was formerly Southeast, and St. Francis Medical Center. Both of them wonderful folks, wonderful institutions, but they also have this rule that they are not allowed to collaborate with any nurse practitioners that are not within their system. They have to hold on to those doctors to have those collaborations with their providers. I understand that. So we have had an incredibly difficult time finding someone to collaborate with our nurse practitioner. We have one person. He is unaffiliated with either hospital at this point, but he is facing retirement. And our concern is that we will not be able to find somebody. We actually, when Southeast was bought out by Mercy, we approached them again and said, hey, you're a new organization. What can we do? How can we make this work? And we've been told they will not work with us. The mentorship that our safe care provider has with their child abuse pediatrician mentor, Adriana James, is completely different than the collaborating practice physician that they work with. He comes to our office once a month, signs off on 10% of the charts. He does, what he needs to do, but he is not trained and does not have the expertise that the child abuse pediatrician that we work with has. It's a financial burden. I'll just be honest, we're paying $500 a month to this person to come here and review these charts, and he does not know what he's looking at. Again, he's an incredible doctor, but he has no specialized training in working with child abuse victims. Our APRN and the mentor that they work with, they have texting, cell phone, constant contact. I'd say they're in contact at least probably once a week. Any abnormal cases are submitted through a quality improvement system, and they are reviewed for them. It is just a very different level of mentorship. It is redundant. It is a financial burden for us, and we have a lot of concerns about not being able to find somebody afterwards. So I thank you for your time, but I would really urge you to please allow this to pass through. This is a very small carve-out. It's very niche. It is not going to take away from any physicians and the quality of care. It's actually going to elevate it.
Thank you for your testimony. Any questions for this witness? Seeing none. Appreciate your time. Anyone else in favor of Senate Bill 83? What are we at on time? Okay.
Hi, I'll be quick. My name is Julie Seymour. I'm the Executive Director of the Child Advocacy Center of Northeast Missouri. We serve 14 counties from St. Charles County all the way up to the Iowa border. We support all of these pieces of this legislation, but I'm here to talk very quickly about the hearsay statutes that we are asking that forensic interview, that recorded interview to be admissible into court for kids that are 14 years and older. We think that it's very essential that we provide these consistent protections for all children, regardless of their age, and recognize that emotional maturity does not arrive overnight. Children don't suddenly wake up on their 14th birthday and are prepared to go in and testify in court about some of the most horrific things that have ever happened to them, where just a day prior they were legally protected from having to do so. The recorded interview is so crucial for kids of all age because that recorded interview shows what that child looked like, what they sounded like, what they acted like at the time of the actual abuse. Sometimes it can be years before these cases get to court. So a 14 or 15-year-old might be 19 or 20 before they actually get to court. A 12-year-old could be 16 or 17 before it gets to court. So that recorded interview is so crucial in making sure that that judge and jury is aware of what actually was happening at the time of abuse. We actually had a case of a 13-year-old girl who was severely sexually abused. She went through the whole criminal process. We got a conviction. But because of stuff going through an appeals process, that was overturned. This girl is now 23 and a registered nurse, and she's going through the whole court proceedings again, just further re-traumatizing her. If she was just a few months older, if she had been 14, that recorded interview would not have been admissible in court. So that judge and jury would have had no idea. They would see a 23-year-old on the stand, not a girl who was 13 at the time of the offense. When we have these recorded interviews submitted into evidence, our forensic interviewers can come in and testify as expert witnesses. So they can talk about the dynamics of abuse, they can talk about the process of disclosure, and they can provide stats and information and really educate that judge and jury on all of these facets that are included in child abuse. So I'm really urging this committee to consider this legislation and ensure that children continue to receive the legal safeguards they need to navigate these incredibly difficult situations. And by doing so, I think that we can better protect the well-being and honor of all of our kids and all of those that are coming forward.
Thank you. Thank you for your testimony. Anybody have a question for this witness? Seeing none, appreciate your time. This will be our last in favor. Is anybody against here, opposed? Okay, so we have one. How many more left in favor of the bill? Okay, so we're going to go ahead and let's go ahead and divvy up that time, and since we only have one. Yes. Okay. We'll give 10 more minutes in favor then, seeing there's only one.
Okay, I'll be quick. Ward Cook with the Prosecutors Association, we also are in favor of that language in Section 491, 492, admitting the recordings into court. We would advise that we add the language "or vulnerable person" after child in this language. That would be our recommendation. Other than that, I have nothing else.
Thank you.
Thank you.
Any questions for this witness? Seeing none, thank you. Make
Thank
sure
you very much.
Fill out your witness form and leave it there on
Got
the
it.
desk. Appreciate it.
Good afternoon, Madam Chair, members of the committee. My name is Marcia Hazelhorse. I'm the Executive Director of Missouri Juvenile Justice Association, and we are here to support Senate Bill 83, and I don't have anything additional to add that's not already been said. Thank you.
I appreciate you streamlining your testimony. Any questions for this witness? Seeing none, thank you for your testimony. Good morning.
Good morning, Mary Chant, CEO, Missouri Coalition for Children. For all the reasons and testimony already stated, we stand in support of Senate Bill 83.
Thank you. Any questions for this witness? Sorry. Seeing none, go ahead. Yeah. Thank you. Next in favor.
Good morning. I'm Leanne Reese. I'm the Executive Director of the Missouri Court-Appointed Special Advocates Association, and I'm here to testify in support of Senate Bill 83 and specifically the tax credit part of it, the Champion for Children tax credit. We're the state CASA organization. Missouri CASA provides support and technical assistance to 24 local programs in 28 judicial circuits in Missouri. These programs screen, train, supervise caring community volunteers who are appointed by the court to provide best interest advocacy for children who've experienced abuse and neglect. CASA volunteers meet with the child at least once a month, interact with people in the child's life, collaborate with other child welfare partners, and write a fact-based report for the judge. They have two primary goals: to ensure that the child is safe and their needs are met in their current placement, and then to advocate for permanency on behalf of the child. In 2023, there were over 1,800 CASA volunteers, and the CASA program served over 4,700 children. And the Champion for Children tax credit is very important to CASA programs, and it will expire at the end of 2025. So that's why it's very important to us. Most of the CASA programs are nonprofits and rely heavily on the support of individuals and businesses through donations. CASA programs have been able to effectively use the tax credit to encourage donations, and the revisions proposed by Senate Bill 83 would even improve it. They'd increase the percentage and increase the cap, and extend the sunset, which is very important. In the near future, the tax credit will be even more important because VOCA funding, Federal Victims for Crime Act funding, is declining, and programs will need to increase the support from the public. And CASA programs really truly appreciate the support provided by the Champion for Children tax credit. And
Thank you. Thank you for your
Thank you for
testimony. The CASA program in my district does an amazing job, and so thank you for the work that you're doing there. Any questions for this witness? Seeing none. Thank you for your testimony. Did you fill out a witness form?
Yes.
Okay, great. Thank you. Next in favor.
Good morning. My name is Gina Clement. I'm the Executive Director for Capital City Court-Appointed Special Advocates here in Cole County. I'm here in support of Senate Bill 83 as it pertains to the Champion for Children's tax credit. In addition to what Leanne has added, we use those funds here locally. We rely 77% on local support to run our program. and we use those funds to recruit, train, and support our volunteers. I'm going to give you a few examples. Tammy is a CASA volunteer for baby B who was born addicted to meth. She's helping to find community resources for him. Jim's a CASA for volunteer for Sam, who suffered physical abuse by his adoptive parents and was relinquished by them. Because of Jim's support and dedication, Sam has graduated from high school this past May and is now gainfully employed. Tynesha is a CASA volunteer for a sibling group of 3 who suffered medical neglect, physical abuse, and drug use by the mother. She has study sessions with the older 2 children so they can be sure to graduate from high school. So we appreciate the support of the tax credit. We do use it as efficiently as we can. One of our volunteer supervisors can serve upwards of 45 to 90 children. So we are very efficient with the funds that we use. So thank you very much.
Thank you for your testimony. Any questions? Seeing none, thank you. Next in favor? Welcome.
Hi, good morning. My name is Madison Ekrit, and I'm here on behalf of Foster Adopt Connect, which is a statewide nonprofit that helps to recruit, retain, and support foster and adoptive families. And I'm here in support of Senate Bill 83, particularly around the provisions for IDs for homeless children. This would just reduce barriers for the ID, which is useful for getting jobs, housing, stable transportation.
Thank you. Thank you for your testimony. Any questions for this witness? Seeing none, thank you for your time.
Thank you.
Next in favor? All right, we're going to go ahead and seeing no more. Or, oh, no, we're good. We're good. All right. Anyone opposed to Senate Bill 83?
Good morning, Madam Chairwoman, members of the committee. My name is Rachel Bauer. I am Director of Government Relations and Registered Lobbyist for the Missouri State Medical Association. As we can see from the testimony so far this morning, the APRN, the provider, the safe care providers portion of this bill is clearly a portion of this bill that a lot of people wanted to talk about. I'm glad that you extended the opportunity for the opponents so that we could learn about the other provisions in the bill, as well as I'm going to tell you about why we have concerns with the safe care provider portion of the bill. For us, it's really about an expansion of scope of practice in a child protection bill. And as you can see from the testimony, it clearly needs a lot more discussion and maybe be pulled out. And we're committed to working with the bill sponsor to making sure that we can find a good solution to make sure that these kids are taken care of. A few points. The exams that these kids undertake are not just forensic exams. They are receiving medical exams too. A lot of times these kids present and they've not been to a doctor, and they might be discovered for a medical condition and are then referred on to a doctor. And so it's important to have that collaborator there to work with the nurses to make sure that all of those things are caught and taken care of correctly for these children.
Any questions for this witness? Seeing none, could you speak just a little bit to their concerns and what we could do to mitigate their concerns of not being able to have a doctor on hand?
Sure. So recently, there was a law that went into effect back in August that would allow for APRNs and physicians to collaborate without a mileage restriction. They still have to, there's still collaborative practice. So they think, it seems as though they think they have to look locally to find this collaborator, when really they can find a physician that's willing to collaborate that they believe is within a reasonable geographic proximity to them in our state.
Okay. I appreciate that testimony. I think that's a benefit for everybody
It
here
is.
and online who's watching, so thank you.
Thank you.
All right, anybody else opposed to this legislation? Seeing none, we will, Senator, do you have any closing comments?
No, I do not. Thank you.
All right, thank you for coming and presenting this bill with us today. We are going to move to Senate Bill 43. With Senator Fitzwater. Begin when you're ready.
Thank you, Madam Chair, members of the committee. Travis Fitzwater, 10th Senate District,
and I'm bringing Senate Bill 43 before you. Thank you for hearing multiple bills in the first couple weeks of your hearings. I appreciate that. Some very complex and a lot of issues. The foster care issue is very important. We've talked about this, Madam Chair, you and I, several times, and even my wife has bent your ear on this issue, and it's important to us. Foster care issues are important to us. My wife's a licensed professional counselor. She's worked with kids that have been in the foster care system or adopted, and it's traumatizing for a variety of reasons for these kids. Daryl Missy, who used to run the division, the children's division that oversaw a lot of the foster care system, who just recently left. I think he fully retired. He was a foster care kid himself, went through the system, an incredible story. So the intent of Senate Bill 43 is to get kids to permanency by giving them resources. First of all, there's several provisions. I'm happy to talk about them. The first one that you'll see in there is relating to a couple hundred kids in the state that are currently not in really safe places that are really resource rich for them, proper resources. So you're talking about foster care kids with behavioral issues who are in a hospital setting. They're living in a hospital, or they're living in a place that's not really meant to be for foster care kids. And right now, because we don't have some of this language, they can't really be transferred to a nonprofit or somebody who could take them but won't, because they have legal responsibility. They have some of that really prevents them from being able to or wanting to take kids because of the behavioral nature of some of these older kids who may be a real problem. And so we want to provide some language that will fix that to ensure we can get these kids to the facilities that are good for them and not just in facilities that weren't meant for them in the first place. So that's the first kind of big piece you'll see in here. Secondly, you'll have the right to counsel piece, which I've carried the last couple of years. And this is, I think there needs to be more tension in the legal system for foster care kids. And what I mean by that is that somebody going to bat for these kids in the process. Other states that have this, that have the right to counsel, and we started at the age of 14, and it just moves kids through the process faster. It gets them to permanency faster. It gets them to reunification faster. It helps their paperwork get through the system faster, because they're just not. It's just hard with the amount of needs to properly pay lawyers and take care of all their costs to ensure that they're going to bat for kids, also with training and all the necessary pieces to child's issues are very specific. And so there's a need for legal representation for these kids. And I think that moves the needle faster for them in the judicial process. And then I think lastly, what is also very important in this, and there are other little provisions we can talk about too if you'd like. But the last piece is establishing resources through the Supreme Court that can be distributed to the circuit courts around the state that will provide representation. So the Supreme Court will kind of manage that whole council system. And right now, circuits are just inundated with issues, and they don't have the resources to train their staff to help get resources to foster care kids, because there's federal funding to do legal representation for kids and families. The circuits can't get to them because it's too complex. So really, the idea is that the Supreme Court would help train and guide and connect resources to local circuits for lawyers so they can represent these kids well, get them through the system, get them to permanency. Sometimes it's just paperwork that's holding a kid up in a court system to getting to some clarity and some stability in their lives. So that's the last piece. Actually, last year I got $750,000 in the state budget to start this, to do a pilot project in a couple circuits, suburban, urban, and rural district, to try to show that getting representation to these kids is going to be incredibly helpful. It's something they may not currently have. So those are all the pieces, kind of on a grand scheme of things. There are experts here that can talk to you about each of the provisions. I think that will come up. I hope will come up and talk a little bit about that if you have really technical concerns. But I'm happy to answer any questions.
Can you speak I have a quick question. You were talking about the circuits that are pilot programs. Senator, can you just speak to whether or not we've received any data on how that has gone in those circuits and what circuits?
Well, it's just, so the money was approved last year. The Governor Parsons signed it. That is the Supreme Court is developing what that looks like now.
Okay.
So it's still very new.
Hasn't been implemented yet.
They're in the process of trying to figure out which circuits they're going to go to. What does that look like? How do we properly expend those funds and send them there to ensure that legal representation is actually happening? And also another piece of this that I touched on briefly is that there are federal funds available for this representation, and it's just not being accessed by our state because it's just hard to find people that are willing to go to these levels. And then also just the sophistication it's required for a local circuit, a rural circuit like the ones I represent, to be able to go to bat or to fill out the paperwork and get all the federal funding worked out. It would be helpful if we had kind of a central district almost that would help access those funds for local circuits, which is really hard, especially in the rural areas.
So have circuits been identified yet?
I'd have to ask the
Okay.
Supreme Court. I think they're still they want to have kind of the infrastructure established before they start identifying those. But the whole point of me getting it in the budget in the first place was one, last year's bill was similar to this one that I carried, and we were hoping to get that one done last year, but it didn't. But we still worked on the budget side, and the intent was to have a suburban, urban, and a rural circuit getting access to these, so we can kind of
three circuits that are diverse.
Yeah.
Okay. Thank you. Any questions for the senator? Okay, Senator.
Thank you, Senator, for bringing this bill, and I apologize. I know I talked to you yesterday, and I had all kinds of questions on this bill, and I
no
just completely
worries.
ran
It gets
out of
busy
time.
around here. You're learning that, I'm sure.
Yeah. And I still have a lot of questions, but I just wanted to ask a couple of them. So when I started reading this bill, this is on page 1, and it's line 2 and 3. And it says a comprehensive system of service delivery. Can you just explain what that means?
Yeah, so, and by the way, I didn't mention this, but the department does have some changes on some of this language because they're impacted significantly by how this is currently written. And we're working through what that language looks like. And so if you all decide that you'd like to move this forward, there'll be some language changes on that to ensure that the department feels good about what's happening, because they don't want to just be these kids kind of taken out of the hospital system and thrown on them. And I think that's part of it, is that there needs to be some plan for how you take care of these kids. There's a couple hundred of them, and I think a witness will come up here and talk about what that looks like, that are staying in hospitals, in a hospital room. They're living in the hospital. They're living in situations that aren't great, aren't ideal for a foster care kid. And so this is just really kind of pointing to there's got to be a way to take this small population of children and take care of them. And so I think that's kind of the general language that we're wrapping that in.
Okay. All right. It's good. And you?
I was going to ask, when you're referencing the division, you're talking about children's division?
Yeah.
Okay.
Just for clarity.
Because they're still these kids are still under their purview. So they're very impacted by what we're doing here.
Right. Okay. Excellent. On page 2, I have another question. This is line 29, and I'm beginning, as I'm going through some of these bills, beginning to see this quite often, and that's a memoranda of understanding. And in this particular bill, it says, with any facility or campus under state ownership that is appropriate for the program. Just when I read it, it just seems very vague. And I just want to clarify the memoranda of understanding. Is that basically an agreement or a contract between two parties, whether it be private contractors or whatever?
Yeah, and I think the intent of that originally, and I think that piece is going to get changed significantly from the departments, because what happens is we have a lot of state facilities that are available, and it's kind of like, well, if we have all of that, why aren't we putting these kids in properties we already have access to, instead of in a facility that obviously doesn't make sense for a foster care kid?
Right.
But the department did come back, and and I think this still needs to be worked through, but they've basically deleted most of that, and that first sentence is really the piece that will stick in there potentially when we get to the table and talk through that language.
Okay. Just for my own knowledge and understanding, a memorandum of understanding, if I understand it correctly, that's an agreement between two parties But we really don't know what that agreement is, and it's sealed, is that correct?
Yeah, well, some of this too is going to be, because the state wants to partner with the nonprofits that really want to fulfill the need here. There's going to have to be some contracting that happens. It happens all through our statutes,
Right.
where there's contracting with nonprofits to ensure that these kids are actually going to a program that's safe and necessary for them.
Right. But a memorandum of understanding is a sealed agreement to where we can't know what that is, and it's
Some of it's
sunshineable.
probably not going to. It may not be available for if it's pertaining to individual patients or kids. It's
Right,
probably
right.
it's going to be a little bit more deep in that sense. You're not going to get access to that information.
Sure.
But I don't think the department is trying to be in the business of hiding that information from us. I think some of that's going to have to be, we're going to have to know what's going on
Right,
for accountability
yeah. I would-
measures and for our own purview.
Yeah, I would definitely agree with that. Okay, that's all. Thank you, Senator, very much. I appreciate it.
Glad to do it.
I think I understand, and this is how it works, but those MOUs will be in relation to the department with the contracted facility. And
Yeah,
so
and-
I
and-
don't think there's MOUs between the individual and the.
No, there's not, because
the department.
individuals,
Yeah.
these are not adults, so they really can't come under contract with
Right.
the anyway. But the state is on the line for they're responsible for these children, and I think nonprofits are very leery of taking the children because they're not prevented from being sued civilly if they take them, because these are tough kids, but we still need to think for them. And I don't know if the space they're living in currently is the best way to think about it.
Well, I'll just clarify, because that's why I read what it said in the bill. It says department shall be authorized to enter into a memoranda of understanding with any facility. So this is not talking about children specifically. It's with a facility, and it's any facility. And that was my question, since these are basically sealed. They're sealed agreements, basic contracts. They're non-sunshineable. We don't have access to that. I'm just clarifying that. Do I have that understanding?
Yeah, and maybe
correctly?
we get the department in your office and kind of, because I don't think this is not unique.
Okay.
I think,
Well, that's why I was saying, I'm
yeah.
starting to see this a lot pop up in bills, and I'm questioning why, even as legislators, why can we not know what agreements?
And I'm happy to work on language too. If transparency is a concern, I'm always for transparency.
Yeah,
So
perfect.
I'm happy to figure out what that path looks like. Or maybe somebody says, hey, you're way overthinking this. Maybe we are, maybe we're not. But I'm happy to work through language that we're all comfortable with.
I appreciate that. Thank you.
This is aside, but there is a Senate bill that has been filed to make that public. So we filed that bill for MOUs and grants to be made public, so we do know what the contracts look like. So, all right. Any other questions? Senator Moon?
Thank you. Good morning, Senator.
Hi, Senator.
We go back to the first page. I know this is a new program you're looking at, and you might have mentioned some of these. I'm referring to line 10 about the needs that cannot be met by existing state programs. Can you reiterate some of those that you might
Yeah,
have
so I think
talked
this is
about?
again where you have kids with significant behavioral needs or struggles that have been through a lot of trauma. They've had a hard life. And right now the state doesn't have any answer for that necessarily. There may be nonprofits that do, and that's why when you go to the next page, you see the reference to 210-114, the qualified service providers, to give some qualified immunity civilly to ensure that if they take these kids, because there is no state program that fulfills that need, they're at least protected. And I think that's what's preventing some of these nonprofits from actually stepping into that role.
And that was one of my questions too on that page. The qualified immunity does cause me to kind of cringe a little bit. So we need to talk about what.
And that's
that might
fine. And then
include.
there's a witness that can come up and kind of
Okay.
discuss a little bit why that needs to be in
All right.
the thinking on that.
Okay.
At least I hope there's a witness that will come up and give you. If not, there's a lot more discussion to be had there.
Okay. On that page, line 24, have there been any not-for-profits that have been identified to date that might be involved?
Yeah, you'd have to ask a witness coming forward.
Matt's head shaking. Maybe he can tell us a little bit more than that too.
Yeah.
There is a lot to consider there in looking at some of the sections that are also referred to. I'll ask some questions later on those because I don't have any specific ones formed. On line page 16 in subsection 2, it mentions guardian ad litem, and then the child's counsel. Is that and can that be the same individual?
It can be, yeah. So what will happen is the court can appoint that GAL before the age of 14, who's been appointed, has already been serving that client. They can appoint them as their counsel upon the age of 14. And this has happened in several other states that are doing good in doing well in the foster care system. Right now, the state of Missouri, which I know you, Senator, know this, and many of you probably do, is that per capita we have one of the largest foster care systems in the country, which is not good for kids. Like when you're thinking about numbers, states that are much larger than us have almost the same size foster care population. That means that 12, 13,000 kids, whatever the number is currently, because it changes often, are in a system that's really hard to get them to permanency. And I think that's hard for kids. And so this right to counsel is hopefully you get, when you hit 14, some of those kids in that system, all the data shows that it gets to permanency faster. It gets you to adoption faster. It gets you to reunification faster. And so we want to provide those resources to those kids. And foster care kids, before Director Missy left, he told me that it costs $30,000 a year to have a foster care kid, per kid. So we're spending tens of millions of dollars per year on these kids in the system. And so this gives kind of the court some ability to give a kid a new resource, so they're sitting on the side of the table of the kid and not the court.
Okay. And lastly, I had a question I overlooked here on page 2, under section 2. It refers to the consortium of qualified service providers. Can you give me an example of what that might look like?
Yeah, those would be folks that are already providing foster care services to the department that can fulfill this need for that unique set of kids in our state that are living in situations that really don't meet the need for those kids.
Is that going outside of state entities where you might have some?
Yeah, it'd be more the nonprofits that kind of fulfill the needs in this space.
Okay. Thank you.
Any other questions for the senator? Senator, you've been very patient with us today. We really appreciate your time.
I'm glad that you're thorough. This is really important, and I know you have a passion for this. We've talked about it many times. I know you all do. We got to take care of these kids.
Well, it's troubling, honestly, and I don't mean to take up more hearing time, but to spend time with your JOs and in that space with CASA and all of this. This really, I think, is an epidemic we're just beginning to see the ramifications of this, and so to try to work to get ahead of some of this and mitigate it is important. So thank you.
Thank you.
Anybody here to testify in favor of the bill?
Good morning again. My name is Mary Chant. I'm the CEO of the Missouri Coalition for Children. We are an association of child and family serving organizations that work throughout the state of Missouri. A number of our members work with children and families who are engaged in the child welfare system, including foster care case management, and some of our members also provide residential treatment services to children who are in the foster care system, and we also have members who operate PRTFs as well to serve those. I want to thank Senator Fitzwater for introducing and sponsoring Senate Bill 43. We are very appreciative. We, I think, support the direction and the concept of all of the major pieces in it. We understand that some of the language is being worked on and that some things are being tweaked as we move forward to really fine tune. We also want to thank the Department of Social Services and the Children's Division for their leadership in trying to address the issue of children with high acuity needs that are in our foster care system. I know that a member will go over that in a little more detail, but it is clearly an issue. Many of our members who provide services for these are working on enhancing and building out programs that are more responsive to these changing needs, but it is not a simple process in any part, from the staffing of it to the financing to the addressing liability issues. So we appreciate the department's attention, and we appreciate Senator Fitzwater's leadership. We look forward to continuing to work on this issue so that we can develop a better response so that we can serve Missouri's children and older youth in Missouri in settings that are fitting and responsive to the needs they have. And we certainly have work to do on moving that forward. Lots of great intent, lots of great support, and we are just, it's a very challenging issue. I'll be quick. I also just want to add that we very much support the focus on legal representation, and the focus on it being on children as well as parents and families. And we believe that quality legal representation is key to what Senator Fitzwater talked about, really getting people to permanent solutions, getting people either reunified, preventing children from coming into the foster care system who do not need to, who can stay at home safely, as well as just moving through the legal issues swiftly and effectively. I think the important is quality legal representation. There is representation for children and parents at different parts of the state. It's uneven because it's unevenly resourced, and there's no core system, there's no central system really to man that. So we very much support having a centralized location. We, as was mentioned, there are federal funds, Title IV-E funds, that can be used both as match for actual representation, as well as training and support for case management and supportive services connected to representation for families. So again, thank you, Senator Fitzwater. Thank you, Madam Chair and members of the committee, and I stand for any questions.
All right, thank you. Any questions for this witness? Seeing none, thank you. Make sure you leave your witness form for this one as well. All right. Next, in favor? Good morning.
Good morning, Chairperson, esteemed members of the committee, and fellow advocates. My name is Matt Hale. I began as a case manager in 2003 and proudly took over CEO of Children's Permanency Partnership in 2022. Children's Permanency Partnership is a collaboration of nonprofits, Family Forward, Youth in Need, and Upworth. We provide alternative care, foster care services in the eastern region of the state currently. Currently, we are serving 675 kids in that region. We also have 550 licensed foster homes, relative homes, and treatment foster care homes that we support. I'm here strictly to talk about the need for the creation of secure therapeutic placements to serve the special new client we are seeing that we're talking about, the extreme 10%, the 14 to 18-year-old children that have suffered trauma upon trauma and are distributing extreme behaviors. I went off my nose. Sorry, first time. Indirectly, these aren't bad kids, these are children in crisis. And the result of that crisis usually results in extreme aggression, self-harm, difficulty with emotional regulations. It makes it nearly impossible to find current placement for these children in the state of Missouri. We explore traditional foster homes, above-level foster homes, residential homes, even our own treatment foster homes, and we're not able to currently get them placements in those homes. At any given time, I have 7, 8, 9 children out of those 675 that are possibly on their last placement or already in my office. We currently have partnered up with a couple of residentials in the state of Missouri trying to create a program to meet these needs. So I do think we have stakeholders that are willing to invest in this cause. When we look at the children in our office or in hospitals or in hotels, what we see significantly, and I only speak of CPP's percentages, we see 32% of them having juvenile justice involvement. We see 27% of them diagnosed with autism, and we see 55 of them diagnosed with PTSD. 100% of them, however, do have some form of mental health diagnosis. 43 provides an opportunity to focus on specialized approaches to support these children, ensuring that they are placed in environments that they can receive care, therapy, and emotional support they need to overcome their challenges to stabilize, so we're able to get them in a loving, caring home, nurturing environment. The lack of appropriate, stable environments to support their healing often leads these children to being placed, as I mentioned, in our offices. And what I can tell you, foster care case management staff is created to rectify the situation that brings the child into care, provide resources. We are not trained residential staff. We are not trained therapists. These kids are not in residential buildings. They're in business offices being supervised by staff 24 hours. We must invest in development, the placement that creates a safe, secure, and therapeutic ways to meet these children's needs, and we must wrap around services to support these children. I would like to thank the Department of Social Services, Department of Mental Health, and others, as there has been extensive work on this problem by stakeholders and committed professionals at all of the departments, as well as site visits to New Jersey and even facilities within the state of Missouri. We are very excited about the new leadership of Department of Social Service and Children's Division. Thank you for your time and your commitment considering the urgent needs of these vulnerable children. It's not written down, but I can tell you, in 20 plus years of foster care, I've been blessed every single day. It breaks my heart to see these kids come to us in their most time of needs. And my staff, we do everything, but we're case managers. We go to court. We advocate for, parents to do services, or for, if parents haven't done services, to get these children adopted. And you see these kids lose hope in your office, and they just go down a spiral. And if we don't help these kids now, we know how they end up, unfortunately. So I appreciate the time, and appreciate bringing it forward, and if there's any questions, then sorry if I rambled.
Where did you drive from?
My office is we got multiple offices. I live in House Springs. I'm from Jeff County, but
Okay.
my office is out of St. Louis.
Okay, thank you. Any questions for the witness? Thank you for your time. I do have one question in reference to the classification and percentages of the kids with special needs. Can you just reiterate that if you would?
Yeah, and that was just my agency's number. We kind of dove into them and we looked, and what we see is, 32% of those children that are currently in our offices or in the hospitals that we have in the hospitals that it's ready for release, but there's no placements, or even out-of-state placements that we've had to utilize. 32% of them have juvenile justice systems. These children tax every system that we work with. That's why we've actually had so much collaboration trying to create support for these children from all the departments, which is great. 64% is diagnosed with ADHD. 27% is diagnosed with autism. That has kind of been an increase in the past year and a half, seeing these children coming in to care with more with autism diagnosis at a higher rate. And 55 is diagnosed with PTSD. 100% of the children that have ended up in our office do have some form of mental health diagnosis, though.
Thank you for your testimony and for those statistics. It's interesting to me that especially with what's going on in the federal government, we're seeing an increase of the conversation of talking about food in relation to some of these mental health issues and, dyes and things like that are maybe contributing factors. I would love to see us have that kind of conversation also at the state level, but thank you.
All right, thank you.
Testimony. All right, next in favor.
Madam Chair, members of the committee, Alex Eaton, registered lobbyist for the Center for Rights of Abused Children. We would like to go on record in support of this bill. Appreciate Senator Fitzwater working on this in the past couple of years, and appreciate you guys listening to this early. Happy to take any questions, but we specifically like the right to counsel piece in the bill. So Thank you very much.
Thank you. Any questions for the witness? Senator Moon?
This is not a question for Alex necessarily, but I meant to say to Matt when he was at the witness table that after our meeting yesterday, our staff and I have gotten together and we've been throwing around some different ideas, and so you piqued our interest in a lot of different ways, and I'm hopeful that in the coming days, weeks, and months perhaps that there can be some significant input perhaps and maybe some good results. But thanks for all the work you're doing. And I know your heart's in it, and so I'm grateful to you. And Alex, no deference to you, but I just want to take that time before I missed it. Thank you.
That was not a direct question for the witness, was it? All right, next, in favor? David, fill out a witness form.
Yes, ma'am.
All right.
Madam Chairman, David Wenton here on behalf of a few groups, Brightly, which is the organization that comprises Preferred Family as well as Burl Behavioral. Family Forward, which is one of the members of Matt's CPP group, as well as BJC Healthcare. For obvious reasons on BJC Healthcare, these are kids that are boarding in our hospitals for 400 or 500 days at a time. We're glad they're safe. We're glad they're in a place where they're getting food and things, but we can't meet their needs. And so I think just a couple of things very quickly. First of all, I know Alex has a huge heart too. Just, I don't want him to feel not special.
You can slip him a 20 later.
Thank you, Senator, for bringing the bill forward, and for all of you who have really spent time. I've been fortunate to get to go on some of these site visits to New Jersey. This is an issue that affects a lot of the organizations that we represent, and I just want to tell you how much we appreciate the work that the departments have done on this. They've been amazing partners. Everybody has recognized the need to do something here, and it's not every day when you get everybody behind something. So I feel optimistic. I've been doing this for a little while. I feel pretty optimistic that there's a solution out here. I want to just address the one question I think Senator Nicola had, which was the MOUs. These MOUs would be open to everybody. So these would be MOUs between, perhaps the Department of Social Services and the Department of Mental Health or somebody else, where they would essentially take over one of the facilities that's been mothballed. We got a chance to go to a facility in Rich Hill, Missouri, in Senator Bratton's district that used to be a DYS facility. It's not being used anymore. The community was incredibly supportive of that facility when it was a DYS facility. It's perfect for these kids and to bring in the best in class from various organizations. There are nonprofits across this state that are not just willing to, but anxious to be part of this solution. It gives us the opportunity to find a really good opportunity for these kids to begin recovering and get on the road to where they need to be successful adults. But just as important, it also lets the groups like Matt's and others really focus hard on the kids that are in their custody that belong in those areas, that belong in those consortiums, so that they can do the work for those kids as well in order to get them into permanency and get them into self-sustainability over time. So thank you all so much for doing this. Thank you, Senator, again. Thanks to the departments.
I know, I was just going to add to your comments and just say I know that there's a couple hospitals in my district that are housing some of these youth and have been there for over a year. And so the hospitals are really not equipped to deal with some of these high acute kids. And so thank you for your testimony.
Thank you.
All right, any questions? All right, thank you, David. Next, in favor?
Good morning. I'm Liza Weiss from Missouri Appleseed. Thank you so much for allowing me to speak in favor of the bill, and thank you to Senator Fitzwater for filing the bill. We are here to express our support for the client-directed representation aspect of the bill, allowing children in foster care to have lawyers that express their interests and fight for their interests is a practice that's supported by the American Bar Association and the National Association of Counsel for Children. Other states such as Alaska, Arizona, Louisiana, Nevada, Idaho have all been moving in this direction. Colorado, and for even children younger than the age of 14. Research shows that when children and parents have robust representation, their time in foster care really drops and they get to reunification or permanency sooner. So we're really excited about this prospect, and thank you so much for letting me speak.
Thank you. All right, any questions for this witness? Seeing none, thank you. Next, in favor?
Good morning, Madam Chair, members of the committee. My name is Marcia Hazelhorst with Missouri Juvenile Justice Association, and we are here to testify in support of Senate Bill 43. And particularly, we are very appreciative of the efforts to introduce legislation that addresses, a need for a comprehensive system to serve children. As previously testified to, we have several children that are displaced. They're not in appropriate placements that adequately serve their needs. And we think the senator's legislation does a great job of trying to give the Department of Social Services Children's Division the authority to make the decisions that they need to and partner with some of these youth-serving organizations. I, too, want to echo how grateful I am to the Department of Social Services Children's Division. I know some of them are here today. I've had the pleasure of working with them the past year to voice any concerns on behalf of juvenile officers and other juvenile and family court professionals in that field. So we really appreciate the senator's efforts. Also, we definitely want to talk about the client-directed counsel and representation for children. We also had the pleasure of working with Senator Fitzwater last year and talked through some of the concerns that we had with that model. We think he has very adequately addressed many of the concerns that we've had previously with moving to a client-directed model. This legislation keeps a guardian ad litem in place, which we feel serves a vital role for children. They serve the best interests of the child, and we think that is incredibly important and needs to be in place. But moving to a model that allows for GAL up until 14 and then still allows the GAL beyond that, but then allows the client-directed counsel to be appointed. So we support that concept. The only questions we had in the bill have to do with the coordinating board, the establishment of that coordinating board, which we understand would oversee representation for children. Our concerns around the coordinating board language just have to do with what the authority the board has, the duties specific to the legal representation fund, how that will be dispersed, who makes those decisions. We just also have some questions about whether or not counties who currently pay for representation for guardians ad litem, as well as parent representation, do those counties pay into that fund, and then that fund is distributed out to various circuits? Is there going to be like a formula? Just some questions around that language, and I assume that's probably still being flushed out. So with that, I'm happy to answer any questions.
I appreciate those questions. Those are really great questions, and I'm confident the senator will be willing to work on those. So thank you for your testimony. Any questions for the witness? Seeing none, thank you. How many more do we have in favor to testify? Okay, just one more. All right.
Oh my gosh. All right.
That's not a sign.
Yeah, we're all good. Hi, my name is Madison Egret, and I'm here on behalf of Foster Adopt Connect, which is a statewide nonprofit that helps to recruit, support, and retain foster and adoptive families. And thank you to the senator for introducing this bill, and we just want to emphasize our support for any efforts that are really being done to help address the needs of foster youth, particularly of those with high needs, and as they're aging out of the system. I think it's really important that we're addressing those needs while they're in care, so they can have a better and more stable transition to help make sure that they're successful on the other side of the foster system. Even further, there's a lot of shared needs across the foster population and those who are aging out of DYS. Like one of the previous witnesses attested to, that there's a really high percentage of overlap between kids who have had experience in DYS and are in the high need category of the foster system. So just really emphasizing the importance of trying to provide as much support and planning and care that we can to this population, and particularly based on their needs, not just what system that they're in, whether that's foster or DYS. So thank you.
Thank you for your testimony. Any questions for the witness? Seeing none, appreciate your time.
Thank you.
Anyone here to testify against Senate Bill 45 in opposition?
I think mine's technically a little bit of both.
Begin when you're ready.
All right. My name is Laura Underwood, and I represent a group of family law attorneys and former judges, mental health professionals throughout the state of Missouri. I'm an attorney here in Jefferson City. I've done guardian ad litem and family and juvenile law work for almost 20 years, represent kids and parents depending on the situation, and have been involved in the juvenile justice system for almost 20 years. We are in support of most of the language regarding the fund, the board. We're happy to see it going through the Supreme Court now. That was one of the things that we discussed with Senator Fitzwater last year, was having it go through the court, as attorneys are regulated by the Supreme Court, as opposed to having it go through an executive branch. We're glad that that change was made. We have some of the same concerns about how the funding would work as Ms. Hazelhorst has. I think we've discussed that with her as well. But overall, we understand the process of it, and we've been thankful to work with Senator on making some of those changes. The primary concern we have now is regarding the requirement that a court assign an attorney at the age of 14. We would prefer that those shalls be mays, that they be up to the discretion of the judge at that time. Guardian ad litems can and do file paperwork for their clients all the time. They can and do advocate for their clients all the time. I am frequently calling my caseworkers, say, what are we doing? Why hasn't this been done? Have we looked into this resource? Have we looked into this resource? And if necessary, going before the judge to say, hey, judge, tell them to do these things. And I know lots of other attorneys who do the exact same thing. I think one of the things that we are forgetting about is I have basically the Children's Division here in Cole County have roughly 30 cases, 30 kids on their caseload. And that's too many. They can't do half the things I need them to do to get my kids out of foster care when they've got 30 kids that need that same level of care. So one of the things that we need to think about funding is not just the attorneys. I always appreciate funding the attorneys for guardian ad litem and for counsel for kids, but we need to fund Children's Division. And I know that Senator O'Loughlin has mentioned that she would like to see more funding for Children's Division, for caseworkers. I think that some of the issues that we see with these other states that have, a little more robust way of getting through the system is not just because the kids have attorneys, but because they're properly funding the services for these kids. I've got situations where I have got kids that are in adoptive homes, but I can't get them the services they need so that I can get them adopted. And that's because I don't have the services here funded through the state. I don't have the workers to hunt that down. I've got kids that are in dual jurisdiction of Children's Division and DYS because of their violent behaviors. But again, I don't have the funding. I don't have the caseworkers to get these things the way that we need it. And I'm sure most of these organizations that are here to help kids will tell you we need the funding. And while, again, I'm thrilled with the funding for more attorneys for kids, for guardian ad litems, and attorneys for parents, because that's a huge thing too. We have, Cole County, we fund our parents, and that moves things along, and it adds tension to the system. But lots of other counties don't do that. And so that's just as important if we're talking about funding, is to get parent attorneys and to fund our services. Because even if I am the attorney for my 14-year-old child and my 14-year-old child is trying to direct me to do something, if there's no funding in the state to do that, doesn't matter what the judge tells me to do. The money's not there. Any questions?
Thank you very much for your testimony. Is there any questions for witness? Seeing none? Did you leave your
I
witness
did.
form? Perfect.
Thank
Thank you
you.
very much. Appreciate it. Is there anybody else here in opposition? Good morning.
Good morning. Lisa Panette with Armorvine. Let's see. I want to start with an article to see how this bill weaves into what I think we're really doing, because I have collaborated with other states to see about their residential facilities. In California, parents may lose custody of the child if they resist gender transition. Why is this important? Well, in this article, it says this new legislation titled Transgender, Gender Diverse, and Intersex Youth Empowerment Act seeks to prioritize the, quote, health, safety, and welfare of children, placing a spotlight on affirming a child's gender identity. Tennessee, they actually called me and they warned me about these residential schools, at-risk schools, and how they're promoted, and now how they see that they're being weaponized against very loving parents. These choice-based schools or programs, they're supposed to provide an alternative path for students who, for whatever reason, quote, don't fit well into a traditional school environment. So there's many of these that already exist out there. But I want to talk about the specifics in the bill and how this weaves into the conversation. On page 16, appointing a counsel under proceedings under sections 210.110 to 210.165. This 210.110 includes emotional abuse. It also includes investigations under 210.115, number 4. It says a medical treatment for a religious belief for that reason alone, very important, shall not be found to be an abuse or neglected child. Okay, so that's a protection for us. But then it goes on to say, however, the division may accept reports concerning such a child and may subsequently investigate or conduct a family assessment as a result of that report. Such an exception shall not limit the administrative or judicial authority of the state to ensure that medical services are provided to the child when the child's health requires it. It also references homeless. Homeless is no longer what you think of as this abandoned child on the street. Homeless now is under what we call a McKinney-Vento. That is the Homeless Assistance Act that authorizes federal education for homeless children. The National Center for Homeless Education talks about its support for the LGBTQI youth at risk. And according to their website, 28% of the LGBTQI youth experience homelessness due to family conflict related to their sexual identity or orientation. So in other words, they're taken from loving families because they don't agree. 210.135, and I'm glad the senator actually mentioned that they're worried about getting sued, because apparently this bill is going to take care of that, because it's going to give immunity from any liability, civil or criminal, regarding the removal or retaining of a child pursuant to the very sections I just quoted to you about emotional abuse, and also those investigations that would take place. So if they are abusing any of this, there would be no consequences, and that is unacceptable. Now let's go a step further. We're going to hand them over a lawyer. We're not saying how much they can get for this lawyer. Apparently it's limitless for this lawyer. So they're going to get top of the line representation now to potentially go after the very loving parents that don't agree, because there's emotional abuse involved. And by the way, section 210.140 says that these communications with the lawyer will be privileged. So we won't be able to see them. So when we talk about the service providers being licensed and accredited, that's a problem. We don't know who's going to do that. As well as they're going to meet any additional requirements on page 2 set by the department. The department's going to do that to meet the best interest of the children that they serve, which is also what the court is deemed to do, just so you know, meet those very interests. And based on the authority for a department that's missing many children, we're now going to do this. The department shall be authorized to enter into mementos of understanding, and even though they could be sunshined, unless it's prohibited, that contract could prevent that as well, unless it's prohibited. The facilities can literally just be about anyone, because when they reference who it's going to be, it says it shall not be limited to. So it opens up to anything. Page 2, line 4 talks about the provisions of 210.114, and it shall apply what is giving qualified immunity to private contractors. So you again let the department make the rules, but you give a severability clause, because why do we have a severability clause in there? Because clearly this is not constitutional. Every time there's a severability clause, it's because they know what's doing before it. It is not constitutional. And on page 35, they can accept literally money from anyone. So I would just want to explain to the committee that what has happened in the past is this has been illegal everywhere for all of these entities to receive money, to receive donations, because if you can buy whatever that entity is. And we're literally seeing this language now everywhere, where now, instead of where it was illegal before, now we can give donations. So think about that. Any bad actor can now be donating privatized money into the system, and, you know, I mean, money talks. So this is the long list of reasons why we're opposed, and I just want to thank people in the state of Tennessee that actually alerted us to exactly how these were being used and weaponized against good people. That concludes my testimony.
Thank you, Mrs. Panett.
Yes.
You said quite a lot here.
I did.
And thanks for digging into the nuts and bolts of this. But what it did is just elicited a whole bunch more questions from me to discuss, which we don't have time. But I want to just encapsulate a little bit of what I heard you were saying. So a child, a minor child living in a home, feels like from their parents they're emotionally abused. Is it for any reason? Just I'm emotionally abused?
I mean, it doesn't say. So, I mean, I guess it's just wide open.
And so they can be taken from their home. The child can be removed for the emotional abuse.
This is a guess at this point, so my educated guess would be after those assessments take place, whatever they call those assessments, investigations, then there's a potential for them to.
So from your research and looking in these statutes, which is very difficult, you know, when we get these bills, we have all these numbers and statutes to dig into, and it's very difficult all the time. So are you saying from these statutes with the emotional abuse, the medical treatment, the immunity from civil and criminal penalties, these kids can be taken from their parents and the parents are going to lose their rights over the kids? Is that
potentially. And if you have a really good lawyer, I mean, we know what really good lawyers can do.
And nobody else is held responsible?
No, they won't be held responsible. I mean, that's as the bill is written.
Okay. Is there any questions? There's nobody else over there. Okay. It's just us two. Okay. Perfect. Well, thank you very much for your testimony. I appreciate it.
Thanks.
And we are really running quick on time here. Did you have something quick that you would like to for informational purpose? Perfect. Okay. I guess I can adjourn by myself.
I'll be really quick. I'm Leanne Reese. I'm the executive director of Missouri CASA, and this bill, this is just testimony for informational purposes. This bill modifies Section 210.160, which is the statute that allows courts to appoint CASA volunteers, and the language appointing CASA volunteers is connected to guardian ad litem duties. So we just want to make sure that CASA volunteers can be appointed whatever type of legal representation is provided to children. And so we plan to continue to work with Senator Fitzwater to make sure that that happens, and just wanted to testify for informational purposes. That's
Well,
it.
thank you very much. Did you have something really quick, sir? Okay, thank you.
Sorry, Mr. Chair, members of the committee, Eric Jennings, Supreme Court Government Relations Counsel on behalf of the Judicial Conference. We appreciate Senator Fitzwater seeking input on this bill, current version and prior versions, and we're glad to continue working with him on that. Thank you.
Thank you very much. With no more public testimony, because we are out of time, Senator, would you like to have any closing remarks?
I think there'll be plenty of discussions around it. Thank you, Senator.
Okay. Thank you very much for bringing this bill to our attention. I appreciate it. With that, that'll conclude our hearing on Senate Bill 43. And
if anybody else still has witness forms to fill out, feel free to leave those at the front here. I'll collect them here in just a couple minutes. Thank you.
Okay. We're adjourned.